Welcome back to Winning Isn't Easy. Sometimes court cases read like mystery stories, sometimes they read like fairy tales, and oftentimes they'll read like horror stories. So let me tell you the horror story of a Florida personal injury law firm that got sued because it ignored Public's group health care lien on the proceeds of a personal injury settlement. Now, just as many ERISA group disability plans and policies have provisions that any personal injury settlements are offsettable against the payment of disability benefits, many ERISA group health plans and policies also have reimbursement provisions. They require reimbursement for group health care benefits that the group health plan or policy have provided from the proceeds of a personal injury settlement. Just like a personal injury law firm shouldn't ignore a disability offset, they shouldn't ignore the group health carrier's lien, or they can be sued. And that happened in the case of Public Supermarket versus Figueroa, a Middle District, Florida case that really should have set them on their ears. Let me set the stage here. Publix is a large grocery chain in the Southeast, and it sponsors a group health benefit plan that provides medical expenses and benefits to eligible employees and their dependents. The plan was self-funded, and that means the money comes out of Publix's pocket. It included a reimbursement provision that required reimbursement for healthcare benefits that Publix paid on its policyholders' behalf from the proceeds of any personal injury settlement. So Paul, a Publix employee, was enrolled in the group health plan. He was the parent of a minor child who sustained injury at birth. Horrific. But the plan paid $80,000 in medical expenses, and they wanted to be reimbursed. The child's parents retained the law firm of Diaz Arguella and Trajeda, who filed a medical negligence action, and it was settled. The settlement proceeds were placed in a designated structured settlement account established by Paul. Now, additional funds were deducted from the gross settlement that remained in the law firm's trust account to deal with the lien. Publix filed an ERISA claim of action against the law firm to obtain reimbursement, and they sought what's called a constructive trust or equitable lien. Publix said, look, the law firm's refusal to provide us with reimbursement in the amount that was paid violated the plan, and we're entitled, said Publix, to equitable relief under Section 502A3 of the ERISA statute. Publix sought a declaratory judgment that construed the ERISA plan and the inapplicability of the make-whole and common fund doctrine. They claimed it was entitled to priority reimbursement. So one of the things that we used to argue, and it depends again on what state you're in, is that Paul did not recover the full value of the case and was never made whole. And as a result, companies like Publix should not be made whole themselves because they weren't made whole by the settlement in the malpractice case. Unfortunately, that's not always what's happening these days, particularly in view of Supreme Court decisions. So the law firm said, look, we're going to file a motion to dismiss this lawsuit that Publix filed. We're not a party to the plan. The claim was against them wasn't valid. In other words, saying, you really should have sued my client, which I think is silly. And the complaint was a claim for monetary damage that is more properly litigated in state probate case, and it's not an ERISA issue. And that the nature of the lawsuit created a conflict for the law firm, that the underlying negligence action involved a minor, and as a result, this whole thing required supervision by the Florida probate court, and that Publix had failed to include in its complaint a complete version of the policy or plan or any evidence that it had paid for the medical services it claimed. Well, guess what the court did? The court threw out every one of these arguments. So before you settle a personal injury lawsuit, you need to make sure that you have a copy not only of your ERISA disability policy, but the ERISA health insurance plan or policy. Read it cover to cover so that you understand what it says, and you better give it to your attorney, and you better make sure that your attorney doesn't stick their head in the sand and ignore the overpayment reimbursement provisions. Don't make a mistake that can cost you your group health and disability policies. Why do I say that? Because group ERISA disability insurance carriers want to be reimbursed, as do group ERISA health insurance carriers. They will not only sue you and your attorney, but they can reduce future disability insurance benefits. The same holds true for ERISA health care plans and policies. They want to be reimbursed, and they will often deny any future medical care to any member of your family covered under the group disability, the group health policy until they're reimbursed. So the lessons learned: just don't mess with an offset. Well, that wraps up our podcast today. I hope you've enjoyed this podcast and that you subscribe to future editions of the podcast. Leave a rating or review. Talk to you next time. Bye.